I became aware that on 9 May 2025, a meeting was held in my absence with Advocate Johnson, Mr. Sissoko, and Mr. Sissoko, where the investigators, Mr. Perumal and Padiachi, complained that they could no longer work with me. They cited my April 2025 affidavit regarding Mr. Rapesu's victimization. But I suspect it is because I was not going along with the irregular investigation processes. I had no knowledge of the process of the investigation, notwithstanding my instructions to be kept informed. At one point, I received affidavits from witnesses who had been referred to as Section 204 witnesses. I had not been consulted on possible Section 204 witnesses. I was also given the affidavits that were already commissioned. I had previously informed Advocate Johnson that I had not perused the Section 204 statement, to which she replied that it was discussed with her and she approved of the Section 204. When I was told that the distrust related to my affidavit, I asked Mr. Sissoko whether it was because I mentioned in my affidavit, 1, Advocate Johnson had informed us in the meeting that she had met with Minister Mkhunu, or perhaps the fact that I had mentioned General Kininda had been mentioned in our project diversion meeting, or perhaps that we were investigating Mr. Nkabinde. Mr. Sissoko responded that it was probably all of the above. It was also during this time that Advocate Johnson instructed us to effect arrests on project diversion every 2 weeks, starting from the first week of May 2025. But for reasons that annoyed Advocate Johnson, this did not happen as she'd planned.
Can you just tell us why it didn't happen as planned? What was the issue?
I sent a WhatsApp to Advocate Johnson in a very polite manner, speaking on behalf of the whole team after I was screamed at and belittled by the investigators, that the investigations were incomplete, that there were problems with the statements that needed to be sorted out, that there were contradictions between witnesses, severe contradictions between statements, where the subordinate is even contradicting the supervisor's affidavit. And furthermore, that I had only received all the documentation on the 11th of April. I was still going through everything. It was a lot, and I was not going to be ready.
If we can go to your WhatsApps with Advocate Johnson on page 258, bundle 10, file 10. (258) of file 10. I think we can start on 257 actually.
Okay.
That's where, this is on the 24th of April 2025.
Thank you. Morning, Advocate Johnson. We just had a team meeting on the arrest for first leg. We won't be ready on projected date of 5 to 7 May.
And first leg is what? It's the Lushaba takedown.
Correct. We have 2 statements that will be completed on Friday, and the file I require for possible accused 2 will only be provided by NASCOM on Friday. I will then need time to peruse, then finalize drafting. The docket still needs to be compiled. I am on leave next week, but I will collect the statements on Tuesday and continue working through it, as so that it's not delayed. Dylan and Brian want a briefing from Hansa on the statements he collected. I do not require same as I was updated and the report submitted. I am humbly requesting on behalf of the team an extension to 14 May for finalization of the investigations and drafts.
Then if we go to 258, her response?
It's fine. I will need a final briefing before takedown. Prepare prosecution memo also for DPP perusal. Noted, we will comply. Thank you.
Okay, so you had a basis on which you were saying that we're not going to be ready by 7 May.
Correct.
So can you just tell us, you've summarized here what it is, in your view, were you ever going to be ready?
No.
And is this only in reference to the Lushaba matter or the entire, so second leg as well?
Pretty much. Okay, the Lushaba matter, the two statements and the file from NASCOM was required. With the Mukwele leg, oh boy, the evidence. You know, I think one of the reasons Brian fought with me and stuck his finger in my face was because I said that a nursery book reads better than the docket. It was poor. There was no elements of any offense.
This is the Mukwele.
The Mukwele docket.
But on the Lushaba matter, as I understand it, you were of the view that there was a prima facie case, but whether it fell within IDEX mandate
Correct.
was the issue for you.
Correct.
And Advocate Johnson had said that it does because it's not housebreaking, it's defeating ends of justice, etc.
Correct.
Okay. So when you are informing her here that you want an extension, you're asking for an extension to 14 May on the Lushaba matter.
Correct, for finalization of investigations.
Did that mean that every other arrest was going to then be delayed by 2 weeks? What was the...
The entire project and the projected dates were going to be delayed.
Then we can go back to your statement.
May 2025, Lushaba enrollment. Sometime in May 2025, might have been the third week of May, I had to enroll the Lushaba matter, but I encountered issues with the affidavits that had been filed and asked the investigators to attend to the necessary. I could only make an assessment on the evidence based on what was contained in the statements. The investigators obtained supplementary statements, but this became an issue because the initial statement was so-called Section 204 statements. As stated earlier, Advocate Johnson approved the Section 204 processes without my input. And in circumstances where I had told her that I had not yet consulted with the Section 204 witnesses in order to form a view, I could not understand how we would supplement a Section 204 witness statements.
Explain that to us. We don't understand what you mean by that.
A Section 204 statement, as I explained earlier, is a statement by someone who's a person of interest, a suspect, who's providing vital information that we would not have been able to otherwise obtain. And I'm saying, and I said it to Advocate Johnson, all the 204 statements that were taken in Project Diversion, the deponent doesn't even admit liability. So in order for you to get indemnity after testifying, you must be truthful, honest, and give a full account, including your own involvement. But if you're saying that I was instructed, and there's one statement where they don't even say that what they were instructed to do was wrong, or irregular, or against procedure, or SOPs, or anything. It's just I was instructed. So with this specific, with the Lushaba matter, they had given a witness 204 status, where he is contradicting the statement of his supervisor in the docket. And to be very honest, I didn't even understand why the vetting section of crime intelligence was involved in a situation of, it did assist to an extent once I did read the vetting file with regards to the contradictions of how the process worked and the consultation with Mr. Lushaba in the vetting versus what was said in the docket versus the friend's statement of going to get medical assistance, whereas Mr. Lushaba told the vetting officer that he did not. So there were inconsistencies in Mr. Lushaba's account of events. But that specific 204 statement, he basically said, oh, well, I didn't see, or I didn't really believe the guy, so I didn't sign off on the file.
I understand why why Ms. Sigels Nube asked you to explain this, because it sounds like you're stating a general legal proposition, whereas from your explanation, it seems that what you were saying was that in this instance, it was pointless to supplement
Correct.
this statement.
Okay.
All right, thank you.
Can we just then deal with Advocate Johnson's approach on the 204, which is page 241 of file 10, which is a WhatsApp exchange between you and Advocate Johnson. It starts with the issue of Mr. Nkabinde, but at the bottom of your message at 10:56 on the 24th of Jan already. 24th of January, there's discussions about a 204. This was one
Correct.
of your issues, your concerns.
Correct.
241, the last paragraph in your 10:56 message.
Yes.
You can read from there.
The witness for vetting, the team asked me to discuss 204 status with you, but I have not perused statement as yet. Advocate Johnson replies, Chief discussed with me while he was here. I agreed to a 204.
And then you say thank you.
If the decision was made, nothing I was going to say was going to change it. Even in the later WhatsApps, where I say to her, I'm going to consult with the witness on the Lushaba matter so we don't have the same problem we have in the vetting.
And what did she say to that?
If I can remember, it was okay.
Okay, so in your concern about the 204 started very early on.
Yes, and it was addressed by myself, and then in the fight that I spoke about with Mr. Rapesu, Mr. Padiachi, and Mr. Perumal. We are on a 2813. We are determining the veracity of accusations. How is a witness being given what could essentially be indemnity at that early stage? And correctly so, you're going to get evidence that's going to taint your investigation because you're going to lead in the direction of someone who's a suspect.
Can I just ask a different question about this? In the normal course, at which point do you get to, now it's time to get a section 204 from this particular witness? This is in the normal course of your investigation, eventually prosecution. That's my first question. The second question is, where does the authority lie to make the decision that we will make this witness to be a true? Because I can imagine that there are witnesses that you should be prosecuted, even if they were going to tell on themselves.
Correct.
You know, you say this is too serious. I hope you do that, to say this is too serious to let them get away with, as a 204 witness. So it's really two questions. Is in the normal course of your work culminating in a prosecution, where does the 204 lie decision, as in the process? But two, who actually makes that decision?
With regards to where it lies, as a prosecutor and also from investigations that we've already done, I've not been working with this team on other matters. A 204 will only be approached once the investigation has reached such an advanced stage and all avenues have been pursued to obtain that evidence, and we can't. We then have to make a judgment call on, do we need that evidence more than we need to prosecute that person? And that is the line of thinking of when you decide.
And is it a case of you have now hit the point where if we don't turn this witness into a 204 witness, we will never get this information?
That is where, that as far as myself and most of the prosecutors within IDAC,
Yes.
it is the only time that we would actually consider it.
Okay.
With regards to the authorization, when I was dealing with the Zondo Commission matters, we had a docket that emanated from 2018. We were actually in the process of doing a presentation to allow us to enroll. When DPC and I realized that there was one aspect where we have tried. We had reconsulted with witnesses. We had, the captain had gone and tried to obtain possible documentary. We were at a block, and we really needed that evidence because it spoke to the chain of command with regards to how the money flowed. And when I approached Advocate Johnson about that, we had to do a full prosecutorial memo with the investigator's input. It had to go to the deputy director. The deputy director had to recommend, and then it went to Advocate Johnson for approval. So there's also a paper trail and multiple people approving.
And in this case, was there a paper trail? I mean, you do tell us in summary that she said, well, I've spoken, well, we see it in the WhatsApp messages. Perumal has spoken to me and I agree. Was there ever a paper trail about this?
Except for the WhatsApps, no. Because I would have had to read the statement. I would have to make a judgment call on the evidence. But that's in January, where I don't have any other evidence. How am I going to make a judgment call on a 204? It just, common sense is not being applied here because you being, and I'm repeating it, you're being guided by someone who's already.
So you don't know what Chief Perumal would have said to Ms. Johnson about this 204, if he said anything at all, and you don't know what she would have taken into account because there's no record, there's no paper trail of it. Thank you.
Aren't you putting it too restrictively, though, when you say you would resort to a 204 witness only if you would not get the information otherwise? I'm thinking, for example, of the fact that the test for proving a case in criminal matters is beyond reasonable doubt. And you may actually have the information, but what about, for example, if all you have is a single witness? The single witness does have the information, but you are not sure that that single witness is going to be a good witness. And you are in a position to get a 204 witness, just to make sure that you do skip that line of proof beyond a reasonable doubt. I think it should be a common sense approach that, rather than as restrictive as you put it. I would think. I'm not a criminal lawyer, and my practice, even when I was in practice,
You're explaining
was not a criminal practice.
You're explaining it exactly how I put it. It's just that I sounded a little bit more restricted or restrictive.
Yes.
If there was a single witness and no corroborating evidence, even if it was circumstantial corroborating, yes, then you would. But if it's a single witness and the corroboration, you've already hit your wall of evidence, so you would have to consider it.
Yes, all right. Thank you.
I want to ask about IDAC's investigative processes, because I see that it's May, you're already discussing takedowns, which I understand to be getting warrants of arrest.
Correct.
I've noticed that in all the matters we have discussed, although you have the Section 28 process available, you actually don't have statements from the suspects. And you said yourself that you thought one case was not very strong, the other one, there was a prima facie case of criminal conduct. But some of the questions you still had, I would have thought that if you interviewed the suspects, if you summoned them and you said to them, how did it happen that you were given this position without the vetting process being done? Who actually did the vetting process? Under what circumstances? Then you would evaluate all of that and determine whether there's reason to arrest, charge, and prosecute. But in all these cases, it looks like there was a rush to arrest people and prosecute them when you didn't have the full facts.
Correct.
So why is that? I'm trying to understand why in the process the mechanism available to bring people in to ask them questions so that you clarify issues, why that was not used.
Commissioner Khumalo, even without the processes of 28, a district court prosecutor who has a docket of that nature would ask the investigating officer to file a warning statement. It was not done.
Because I'm assuming that even the prosecutor, because we learned that in one of the cases, there was a prosecution memo. It was sent to the prosecutor, the NPA prosecutor, and then PA prosecutor said, I agree with your decision to prosecute. I would assume that in such a case, that prosecutor would consider, let's say, Mr. Padiaki's affidavit, would look at, but what does the suspect say happened? And would weigh the two and say, I'm satisfied that there's a prima facie case or something along those lines.
Is Commissioner talking about the in consultation or that's signed by the DPP?
Yeah, but let's not use that specifically.
Okay.
In general terms, before you proceed to take down, I would have expected that at least you get those statements to inform your view whether to prosecute or not to prosecute.
Commissioner, I'm going to go back to my first statements. If Advocate can just help, I'm looking for the part where I speak about the orchestrated attack.
The orchestrated attack. Now you're putting me on the spot.
I apologize. Okay, I will paraphrase it, Commissioner Khumalo. I started on last week Thursday by saying that the evidence I'm going to provide to the Commission will demonstrate that there was an orchestrated attack and plan to arrest people. So, and I said it earlier, and I said it again now, common sense doesn't prevail. Regulations don't prevail when manipulation is happening.
It's page 21, paragraph 50.
Thank you.
I'm indebted to Ms. Poe for that.
Thank you, Advocate.
I think you can go from before I deal with the event, so almost towards the end of paragraph 50 on page 21.
It's fourth line from the bottom.
Thank you. Before I deal with the events that transpired from the 6th of December 2024, I want to make it clear that Advocate Johnson and Mr. Perumal launched an orchestrated attack on General Masemola and Lieutenant General Khumalo using IDAC's powerful investigation tools. So common sense did not prevail when the plan and the evidence was being manipulated.
So they could have, but they chose not to because their plan was to...
Correct.
Did Ms. Johnson say why the agency? I accept that if indeed this was an orchestrated scheme, it's understandable that, not as inapproved, but understandable that things would not proceed in the normal course, to follow the rules, to follow common sense. This is why we only act once we've gathered everything. You do a 204 only at a certain point when you've gathered everything. So that would not apply because we have a scheme that in fact we are executing. It's not about legitimate investigation and prosecution of wrongdoing. There's no legitimacy to it. Does she explain, even in that scenario, why we must do it every 2 weeks and why we start in May? What was pushing her? Did she ever say anything?
There was no explanation provided, and as Advocate Surunya explained yesterday, some questions you just don't ask.